Item number 15 in the analogous matter 15 and 16.
Yes.
Lordship, the matter may kindly be adjourned for the day. Lordship, an adjournment slip has been given.
You are appearing on behalf
The appellant, Mr. K.K. Mahanta.
of request.
I am also Premelo. I also seeking adjournment for the item number 15. 15. I am for the respondent.
On request made on behalf of KK Mahanda, let us see counsel for that. This is the matter of 2 weeks.
2 weeks. 2 weeks. Much obliged, sir.
May please, Lordship. I'd like to mention for listing, Lordship. I have for bail, Lordship. Lordship, matter we taken on Friday, Lordship.
Not Friday. 7th June.
Obliged, Lordship.
May I please, Your Lordship? Lordship, with the consent of other side, I'd like to mention item number 4. Due to personal difficulties, my senior G. Chaudhary could not be available today in this court. Kindly, the matter may be adjourned for the day and list.
This is a state appeal against acquittal. On the first occasion, Lordship had condoned the delay. Today, the leave application has come up. But then Mr. Gautam Chaudhary has some difficulty. So
Okay, third name is Jahan, and additional request. On request made on behalf of G. Chaudhary, then the counsel for respondent 1 and 2. When do you want?
After 2 weeks, Lordship.
The letter of the 2 weeks.
Obliged.
Item 1 of daily leave, admission.
May it please, Lordship. My lord, this is an appeal. The matrimonial appeal, my lord, is preferred against an order passed under 25(3) of Special Marriage Act. My lord, the case in hand is this, my lord, that appellant and the respondent here were in love affairs for last 10 years, my lord. Before marriage, they knew each other. They were very much consenting party. He is a businessman, my lord, and she is an MA qualified student. Thereafter, my lord, on 25/1/2018, my lord, they got married willfully. The my lord will find the marriage certificate in page number 73, my lord. This marriage was registered in presence of 73, my lord, for a moment, my lord. Now, what had happened, my lord? See, my lord will see this. They have appeared before marriage register. All formalities have been completed. Witnesses have signed. Parties have signed. No issues there. Around 6-7 days later, my lord, on 5th of February 2018, he files an FIR against me. Probably, my lord, the wife, the respondent, my lord. Very unfortunate. She files an FIR against me stating that I have coerced her to marry on the ground that on 25th of January, she was apparently in Silchar town, my lord, and she was near the head post office. Head post office, my lord, will remember this head post office area is in the heart of Silchar, my lord, Silchar town. On the broad daylight, apparently I, along with around 5-7 boys, coerced her, took her to the marriage registry and forcefully got her married. Thereafter, my lord, on 22/2/2018, she files in suit for dissolution of marriage. That, my lord, will find in page number 40, my lord. 43. 43, the suit is there, my lord. Now, as my lord, my lord will see, this is a suit specifically under 25(3) of Special Marriage Act. Now, my lord is aware, my lord, in this Special Marriage Act under 25(3), it talks about coercion and marriage by force. Surprisingly, my lord, I am not troubling this honorable court with the pleadings for a moment, my lord. So, what she is claiming that her signatures have been forged. She used to come to my business establishment for filling up certain forms and applications, and I somehow forged and signatures of her, took her testimonials and filed it before marriage register first. Then, on a planned manner, as if I knew when she was going to arrive on Silchar, I also reached Silchar town, forced her to marry me before the registrar, before the marriage register. Thereafter, my lord, according to her story, she went back to her home on around 8-10 days later. She filed an FIR. Now, before filing FIR, she says, as per her suit, she says that she has disclosed this incident to her parents. Surprisingly, my lord, the depositions we'll find in from page number 51, my lord. In the deposition, she does not mention the name before whom she had first disclosed this, what kind of evidences she had to prove that there was a coercion. This entire evidences which I have brought by way of two witnesses and one independent witnesses were examined. Everything has been negated on the pretext that whatever the respondent is saying is the gospel truth. And the marriage register subsequently dissoluted my marriage on the ground that she has alleged coercion, and it is my duty to prove that there was no coercion. My lord, very surprising here, my lord. She was a 28 years, to my understanding, my lord, 28 years of age, MA qualified, master degree qualified female. She went before sub-registrar. If she were under any coercion, my lord, if I presume it against me, she would have easily talked to the sub-registrar or would have disclosed it before the sub-registrar. She had brought no evidence, nothing. Still, the learned court below allowed the suit, imposed a cost upon me. Apart from this, my lord, there are multiple cases has been filed against me. I personally believe, my lord, that this all cases have been filed on the instance of her family members' pressure, my lord. So this is my case in nutshell, my lord. If I may be allowed now to take you through the impugned order for a moment, my lord.
That we have seen,
My lord.
we have seen.
If so, my lord, what I am praying as of this now, my lord, is this let the order be stayed, because there is a criminal proceeding going in against me, my lord, that I have mentioned in the page number.
Let notice go first.
Yes, my lord. If on an interim basis, my lord, I may
Notice go first.
the
Mr.
AB there, my lord. Time for the
Mr. AB, then on top of the appellate. Stop.
order may be
This
stayed, my lord. If
appeal is directed against the Dutchman and Victory, dated 27/3/2023, by which the marriage of the petitioner and the respondent was annulled.
Solemn night.
Stop. Issue notice. Appellant to take steps for service of notice on the sole respondent by registered proceeding within 1 week. This is the matter after 4 weeks.
My lord,
Prayer for interim shall be considered
on the next date, may my prayer for stay the order will be considered.
Prayer for interim shall be considered on the next. Yes.
Oblige, my lord.
Two,
My lord, this is an statutory appeal, my lord, against the judgment and order dated 22/3/23 and
First, Mr. J. Payal will not counsel for the appellant. Equity. One for the LCA. MSS John and additional people. Appears on behalf of.
respondent.
One.
I think member. Oh, this one number 1. Appellant to take steps for service of notice on responsible by registered proceeding within 1 week.
There is an IFO, my lord.
After 4 weeks. The I, will counsel for the applicant. Written notice. MSN John and additional people appearing for the respond number 1. Praise for
2 weeks.
2 weeks time to file objections. Prayers allowed. Appellant to take steps for service of notice on the respond number 2 by registered proceeding within 1 week. Please after 4 weeks.
Always.
three, ordered
Paper book is ready. Mr. Hassan otherwise is regular today. I don't know what happened. Three.
Hassan.
Oh, his junior is there.
Yeah, please, Lordship.
Paper
I'm
book is
appearing
ready.
on behalf of Mr. N. Hassan.
You received the paper book.
Paper book has been received. Matter may kindly fix for hearing.
Heard Mr.
Yeah, Ali.
A. Ali, learned counsel appearing on behalf of some learned amicus curiae for the appellate. Also heard MSF Jahan and additional PP Assam. Paper book is ready. Please the matter for hearing and decision process.
Oblast.
5,
May it please your lordship. My lord, the 389, my lord,
Yes.
suspensions of sentence. If your lordship allow me, then I can go ahead. My lord, here,
Objection is there.
Yes.
My objection is there. It is on
Okay.
record.
my lord, just one point. I'm just selling here. My lord, lordship will kindly see if LCR is available, my lord.
It's
The
a POXO matter.
Affidavit, Lordship, we received the affidavit also. And objection also from the
Yes.
respondent.
We don't have the objection.
Lordship.
The system is showing on 21.
You want to press the IA and prepare the paper book? Or
Lordship,
no, you want to press
I
the
want-
IA?
I want to press IL, Lordship.
Okay. Then,
Lordship.
Mr.
B Islam, Lordship.
Heard Mr. P. Islam, learned counsel for the applicant. Also heard Mr. Your good.
Your
name, please?
name. One of the-
SC Das. SC
And
Das.
SC Das, learned counsel for the respondent. It is submitted by MSS B. Buyan, learned addition to the Assam. But she has filed her objections. Stop. Registry is directed to verify and place the same on the court. List the matter after 1 week.
Lordship, date may be kindly fixed, Lordship. IA for IA.
1 week.
Lordship, public.
14,
May I please?
Yes.
Lordship, in this matter, will deposit 10 lakh, Lordship, if Lordship permit.
Why 10 lakhs?
Lordship, at present, he is capable to deposit 10 lakh.
Lordship, 50% of the granted alimony should be paid for to fix it for admission hearing, Lord.
If you debited 50 lakhs, then we'll proceed for hearing.
Lordship, 50 lakh is too high. Lordship, senior is.
Yes, Mr. Mahanna. 50 lakhs.
Milord,
He's quite well off.
Milord, that is of course the perception, what I find. If your lordship kindly go to the independent order, my submission is that there is no iota of evidence. Nothing has been discussed what is the income of the family. Simply 1 crore. On merit, if your lordship be pleased to see, what you will find there is no evidence at all, nothing has been discussed, and it is admitted that there is no evidence has been laid. The learned judge has recorded it. No evidence has been made.
Lordship, it is we are on the course of hearing.
So now, because question of stay, and if your lordship,
Mr. Manda, do you want live streaming?
lordship,
Do you want live streaming or you want to stop the live streaming?
live streaming,
Yes.
live streaming, my lordship is doing live streaming. I have no option that way. But
It's a
if your
matrimonial-
lordship wants to hear the whole matter,
It's a matrimonial case.
metropolis.
So, if you want to proceed, we can proceed, otherwise we can stop the live.
Yes, yes, your lordship can. I leave it to you.
Just headline, what does say, dear lordship? Covers the acts done without premeditation is a sudden fight in the heat of passion upon a sudden quarrel with the deceased without the offender having taken undue advantage and God having acted in a cruel and unreasonable manner. All the ingredients of exception for must be certified. Word and phrases fight, heat of passion, sudden quarrel, These are the, if the words is comes under exception 4. It has relevant portion is a paragraph 8 and 7 and 8, your lordship. So this is the part, your lordship, it has been mentioned, paragraph 7 and 8. If lordship go to the page 397, in the midst of part, I just underline it. Exception 4 can be invoked if death is caused without premeditation, in a sudden fight without the offenders having taken advantage to act in a cruel manner, unusual manner. The fight must have been person to kill, to bring and case exception. All the ingredients must be found. It is to be noted that fight occurring in exception 4 to section 300 IPC is not defined. It takes to make a fight. So this is the part, your lordship, that what this type of occurs, this type of word phrases comes out, then it comes in the exception 4. That is my humble submission as per the Supreme Court judgment. Next, your lordship, 2013 5 GLT 427. This is my lordship own judgment, your lordship, in Sitpal Munda versus State of Assam. Here in this case, your lordship has mentioned in a paragraph 13 and 14. I just go to the headline because all things I have narrated there. PW1, wife of the deceased, and on return the deceased was lying dead. Appellant was not found in the house. Held unsafe to hold appellant guilty mere on the basis of evidence that the appellant was in deceased when PW1 left for rehearsal, but return he was not found with the deceased. By itself, it is not established that a chain of events point to the guilt of the appellant. Appellant held time entitled to the benefit of that and conviction and sentence aside. So here in this also case, your lordship, the full chain of circumstances has not been followed, and it has not been found to be complete circumstantial evidence in this case, your lordship. But my lordship, the judgment in past in relevant paragraph in 13, 14, and 15. It has been beautifully mentioned about my lordship, mentioned more particularly in the paragraph 15. In a, may I read, your lordship? In the Sudama Pandey versus State of Bihar 2012 1 SSC 679, the apex court hold that in the case of circumstantial evidence, the various circumstances should be applied to form a chain pointing to the guilt of the accused. In case where there is only circumstantial evidence, the court has to consider the evidence adduced by the prosecution and decide whether the evidence proves particular facts relevant for the purpose of the case. When such facts are proved, the questions arises whether the facts are capable of giving rise to any interpretation of the guilt of the accused person or not. Inference guilt can be done only if the proof facts are wholly consistent with the guilt of the accused and certainly is entitled to be benefit of that. Here in this same cases happen, your lordship. Thereafter in paragraph 16 also, the sentence which have been mentioned in paragraph 15 has beautifully narrated why it has been circumstantial evidence should be in what manner the circumstantial to be completed. That have been mentioned, your lordship. In lordship, permit me to the next case, your lordship. Just latest judgment on 2002 legal SC 1180. Your lordship, this is a case of Subramania versus State of Karnataka. In same thing has happened in the new trend of this case also. This is relevant paragraph in paragraph 47, your lordship. And the next page is paragraph 52 58. Here is also mentioned, your lordship, murder trial in the paragraph, your lordship, that extrajudicial confession, admissibility and evidentiary value, and it has been mentioned, your lordship, an extrajudicial confession, if voluntary and true, made it a fit state of mind can be relied upon. Confession will have to be proved like any other fact. Value of the whom it has been made, it depends on the reliability of the witness concern. So this is the part in the extrajudicial confession. Then, your lordship.
No, see, if you're praying for 304 part 2, basically you admit everything.
Yes,
You admit everything except the fact that you were in a inebriated state. You were in anger.
Out of anger.
Out of anger, you've done that line of argument. You come. After that, we can dispose of the matter.
That is my humble submission.
Otherwise, going into all this circumstantial evidence or all this,
It will not put
it's
on.
just wasting time.
Wasting time. So I admitted that there is an injuries in the part, health injuries in the medical part as part of medical officer. I admitted also in 313 statement that due to the tussle, it has been happened. I also admitted that there is a data where she has said rightly, wrongly in that 11 point of none other than I am the person. So now in my case, here in this case, it is a sudden provocation which took place, and since she has already been in the jail hazard. So my humble submission is it is a case of the 304 part 2. Is a not culpable homicide, not amounted to murder. The entire my judgment which placed before this honorable court under that line. So my humble submission is that he may be punishment which have been imposed against him is the judgment which has been passed on your lordship on 19 3/12/2019 in page 22. The judgment which has been passed on 22 of paper book, your lordship,
Page?
page 22. Our lordship judgment that relevant point of time she was session judge of Kukrajar. Page 22, 3/12/2019, your lordship. It is more or less 8 years, probably, your lordship. So the quantum of punishment may be lesser to comes under the purview of under the ambit of 304 part 2. That is my humble submission before this honorable court.
Yes. Okay.
Deep.
Lordship, my learned friend is praying for conversion, my lord, at the 304 part 1 or part 2, your lordship. So, lordship, in this case, there are extrajudicial confession for PW1 and direct evidence of PW3, who happens to be the daughter of both the victim as well as the accused person. First, I take your lordship to the evidence of PW3, my lord, whether conviction can be sustained relying on the evidence of PW3, my lord. Page 12, your lordship, the evidence of PW3, the daughter of the both the parties, accused as well as the deceased.
Page 12.
Page 12 of the paper book. No? Her name is Strong Basumatari. Has the lordship got it, my lord?
Yes.
Yes. I know the informant and the accused is my father and the deceased was my mother. The incident took place about 1 year ago at 4 p.m. On that day, my mother, deceased, came to my husband's house, and after 2-3 minutes of her arrival, my father, accused, also came to our house with an axe. Lordship will kindly note that part. He came with an axe. Thereafter, he scolded my mother, deceased, and told her that why she has come to our house and pushed her, and then he, accused, forcibly took her on the road. When my father brought my mother to the road and was assaulting her, I tried to resist my father and told him that there is no need to scold and beat my mother and asked him to take her to his own house. But he did not listen to me, and hence, out of fear, I tried to call another person of village, and at that time my daughter was also with me. When I went to call other villagers, but I did not meet anyone near to the place of occurrence, and then when I returned back, I saw my mother was lying on the side of the road in pool of blood, and my father was standing near to her with an axe in his hand. Out of fear, I could not go near my mother. Thereafter, my father went to his own house along with an axe with blood stain, and he locked himself inside the house. Thereafter, some other person also came near to my mother, and then I saw that she sustained injury on the lower side of the neck of the right side. My mother was already died, and then the villagers informed the police station. In cross, the house of my father is about 1 kilometer far from the place of occurrence. I used to come to my parents' house, and my parents also comes to my house quite often on. My father used to tie the cow near to my husband's house sometimes. My father used to bring and take back the cow. When the occurrence took place, it was dark. I visited inside the mission to call the person at the time of occurrence. A person cannot be seen on the road for the wall of the mission, as it was a big wall. The teacher's room, hostel, etc. were far from the gate of the mission. If someone stay inside the border of mission cannot listen any noise from the road. When I returned back from my mission, my father was standing near the body of my mother. My father used to have alcohol. On the day of incident also, he was in a drunken condition. Whenever he had overdose of alcohol, he could not control himself. We do not love our father accused. I used to have alcohol. My mother was wearing pink dakwana and pink blouse at the time of her death. It is not a fact that my father did not kill my mother, and as he was in a drunken condition while being in the cow, someone killed my mother, and out of suspicion, the FIR was lodged against the accused, my father. It is also not a fact that I have not seen my father accused carrying the axe in his hand. So, Your Lordship, the evidence of the daughter is sufficient to convict. And in 313 statement also, the accused person is admitted, my lord. And question number 19, page number 19, my lord, 2, 3, 4, 5, 6, 7, 8, and 10. The Lordship may kindly have a look at page 19, my lord. It's a 313 made by the accused person. Answer to question number 1. There is an allegation against you that you committed murder of wife with an axe in front of the St. Francis Xavier School. Is it true? Yes, it is true. I have committed murder of my wife. Then question number 2. PW1, the informant of this case, deposed that on the day of incident at about 5 to 6 p.m., you committed murder of your wife by inflicting injury with an axe in Mission Road. He further deposed that you came to your house with an axe and public gathered outside the house, and accordingly you confessed in front of the gathered public. Is it true? Yes, it is true. I have committed murder of my wife. Then answer to question number 3. Here also he admitted, my lord. Question number 4, 5, 6, my lord, 7, 8. Then answer to question number 10. Yes, I don't want to kill my wife. There tussle between us, and suddenly the blow of the axe fall on the neck of my wife and sustain injury. He admitted, but this plea cannot be believable, my lord, because he came with an axe, my lord. As per the evidence of PW3, he came with an axe, and thereafter he chosen the vital part of the body. And if your lordship peruse the post-mortem report at page 40. Page 40, your lordship. And page 41 is the relevant portion. Multiple incised wound and 3 major lacerated wound is seen in right side of the neck, cutting major arteries and vein varying from 10 to 3 into 1 cm with trachea exposed to 3 so just above and below. 1 lacerated wound also found in leg, approximately so and so. No ligature mark is found round the neck. And as per the opinion of the doctor, that is due to shock at page 43, my lord, because of excessive blood loss due to cut of major arteries and vein inside of neck. Time since date is approximately so and so. So, lordship, this accused person is chosen the vital part of the body. Although there may be, lordship, grave and sudden provocation, in the sense maybe the accused person debarred the deceased to come to his daughter's place, which she did. And having come to know, he brought the axe. So intention to kill was there, my lord. And if he had chosen the Honorable Supreme Court in various judgment have observed, if the perpetrator has chosen the vital part of the body, if the weapon of your lordship will consider the nature of weapon used by the perpetrator, then even if there is a case of grave and sudden provocation, my lord, your lordship may appeal the conviction at 302. Lordship, the discussion I leave it to your lordship, whether if your lordship converts it, your lordship may convert it under 304 part 1, my lord. Lordship, in this context, may I refer to the judgment of this Honorable Supreme Court, my lord, 2010 9 SCC 799.
2010?
9 SCC 799, my lord. Para 15 to 20. Para 15, may I read your lordship?
15 to
20, my lord. Here crowbar was chosen as a weapon of offense, my lord. Para 15,
yes.
page 803. In view of the submissions made, we do not deem it expedient to narrate the entire evidence on record. Suffice it to say that all the injured witnesses, namely PWs 1 to 5, have consistently stated that the appellant assaulted the deceased with a crowbar on his head. According to the autopsy surgeon, Dr. Govind Wagmare, death had occurred due to laceration over the vertex of the scalp and multiple skull fractures. In our opinion, as nobody can enter into the mind of the accused, his intention has to be gathered from the weapon used, the part of the body chosen for the assault, and the nature of the injuries caused. Here, the appellant has chosen a crowbar as a weapon of offense. He has further chosen a vital part of the body, that is the head, for causing the injury, which had caused multiple fracture of skull. This clearly shows the force with which the appellant had used the weapon. The cumulative effect of all these factors irresistibly leads to one and the only conclusion that the appellant intended to cause death of the deceased. Now, referring to the decision of this court in Gurmel Singh, the same is clearly distinguishable. In the said case, on facts, it was found that the accused did not intend to cause the injury, which in fact was found to have been caused, and in the said background, it was held that the accused did not intend to cause death, which is not the situation here. In Jagtar Singh, the incident was preceded by a sudden and chance quarrel, and in that background, the court held the allegation proved to be under section 304 part 2. In Gurmukh Singh, the injury found on the deceased was only depression of skull bone, and the occurrence had taken place on the spur of the moment. In the background of the aforesaid facts, infliction of a single lathi blow was not found enough to infer the intention of the accused to cause death of the deceased. Here, as pointed out above, the three important factors enumerated above clearly lead to the conclusion that the appellant intended to cause death. Hence, all these decisions are clearly distinguishable. In the present case, as pointed out above, the weapon used, the part of the body chosen for the assault, and the intensity with which the appellant assaulted the deceased clearly go to show that he intended to cause the death of the deceased. So, the Honorable Supreme Court affirmed the conviction at 302, my lord. In the case in hand, the accused appellant chosen the vital part of the body, the neck, and it's not the case that the only one injury. There are multiple number of injuries on the neck, my lord, which resulted in the instantaneous death of the victim, my lord. And regarding the plea, your lordship, that he was unsoundness of mind and that he was inebriated, lordship, it will not come under the general exception 84, my lord. 84 to 106 general exceptions are there, your lordship, of the Indian Penal Code, my lord. '85, my lord. 84 is the act of a person of unsound mind. Nothing is an offense which is done by a person who at the time of doing it by reason of unsoundness of mind is incapable of knowing the nature of the act, or that he is doing what is either wrong or contrary to law. Then section 85. Act of a person incapable of judgment by reason of intoxication caused against his will. Lordship?
Yes.
Section 85. Nothing is an offense which is done by a person who at the time of doing it is by reason of intoxication, incapable of knowing the nature of the act, or that he is doing what is either wrong or contrary to law, provided that the thing which intoxicated him was administered to him without his knowledge or against his will. It's not the case of the prosecution. Against his will, he was administered alcohol. He's a drunkard, my lord. Regularly used to have alcohol. So it doesn't come under the general exception, your lordship. And those pleas have not been taken. The plea of unsoundness of mind was not taken during trial, your lordship. And it hasn't come on record, your lordship. Then the non-examination of witnesses, my lord. If there is only one witness which is believable, my lord, single witness who is the daughter, lordship, generally she won't give evidence against her father unless he's a perpetrator. Even if it is dark, one can recognize his father or mother, your lordship, in darkness also. So, your lordship, the evidence of PW3, the sterling witness, my lord, star witness to the prosecution, it's enough to convict, my lord, if your lordship believes the testimony of PW3. Lordship, may I submit one judgment on the testimony of sole eyewitness, my lord? Two 2004 to SCC, my lord. 4 to SCC, 455.
Hello?
Para 21, my lord. Page 463. Para 21. The legal system has laid emphasis on value, weight, and quality of evidence rather than on quantity, multiplicity, or plurality of witnesses. It is not the number of witnesses, but quality of their evidence, which is important, as there is no requirement under the law of evidence that any particular number of witnesses is to be examined to prove, disprove, or fact. The evidence must be weighed and not counted. It is quality and not quantity which determine the adequacy of evidence as has been provided under section 134 of the Evidence Act. As a general rule, the court can and may act on the testimony of a single witness provided he is wholly reliable. And previous and subsequent conduct of the accused person, my lord, he came running with a weapon in hand, my lord. Then thereafter with the weapon, he went inside and he confessed before the public, before the PW1 extrajudicial confession is there. It's enough to lordship, sufficient to convict, my lord.
Lordship,
Conviction.
what my learned CP has mentioned, if you lordship again go to the 2004 11 SSC 395, let's see her case. In that case also, the relevant paragraph is a paragraph 8 and 9. The basic issue, the paragraph 8, your lordship, I just read out. The fourth exception of the section 300 IPC covers acts done in a sudden fight. The said exception deal with a case of prosecution not covered by the first exception, after which its place would have been more appropriate. The exception is found upon the same principle for in both wherein in absence of premeditation. But while in the case of exception 1, there is a total deprivation of self-control in case of exception 4. There is only that the heat of persons whose clouds men's sober reason urge them to deeds for which they would not otherwise do. There is a provocation of exception 4 is an exception 1, but in the injury done is not the direct conjugations of that provocation. In fact, exception 4 deals with in the cases which notwithstanding that a blow must have been struck or some provocations given in the origin of the dispute, or is whatever may quarrel which may have been originated. Yet the subsequent conduct of the both parties puts them in respect of guilt upon equal footing. A sudden fight implies mutual provocation and blows on each side. The homicide committed is then clearly not traceable to unilateral provocation, nor in such cases could be done blame to place on one side. For if there were so, the previous deliberation of determination to fight, a fight suddenly takes place for which the both parties are more or less to be blamed. It may be that one of them starts, but it other than if the other had not aggravated it by its own conduct, it would not have been taken the CS turn. There isn't then mutual provocation and aggravation, and it is difficult to appreciate to share a blame which attest to his fight. The help of exception 4 can be invoked if a day's death is cause without premeditation, in a sudden fight, without the manner, the fight must have been taken place to kill, to bring the case there within exception 4. All the ingredients mentioned, it must be formed. It is to be noted the fight occurring in exception 4 to section 300 IPC is not defined. It takes to make a fight. So my humble submission, it is not a one party condition, Your Lordship. It is both parties. Husband in a fight, she also provoke, I also provoke. It comes. The source of provocation starts in one manner. If it is not, if it should not come out, then definitely this type of occurrence never took place. Now, when she came and I put registration, then there is a provocation. Now, when there is a provocation, I have not plead in entire cases as an inherited condition. So my motive is clearly mentioned in the Supreme Court judgment in this case here. So if the motive is clear, then definitely it is a case. And if I have assaulted, Your Lordship, initially I have been assaulted, not to come, but I have not killed. If I have it done, then definitely I done at my home place, Your Lordship, not in a 1 kilometer far away from my place of occurrence. So it is a purely case of the sudden fall, and the Supreme Court has clearly mentioned where there is a tussle, where there is a provocation, where there is a heat of passion. So definitely it comes under exception 4. And assuming, Your Lordship, she is my wife, and why I supposed to kill my wife when there is some point of issue is to be determined in this case, Your Lordship. And moreover, the PW3, if I see in my entire judgment, although I have not mentioned here, can the PW3 judgment statement is trustworthy? Because he also does not like her father. Only on the condition is that when he become overdose, he become mental condition comes out. If you consider the cross exemption of PW3, that also will to be mentioned. She said two things, Your Lordship. One thing is that she called up the co-villagers. She never mentioned about the shopkeepers in that 11 point of time in the where the investigating officer has mentioned. Can the PW3 statement can be trustworthy and reliable to convict? In this case, Your Lordship, my humble submission before this honorable court, although there is a multiple injuries, that multiple injuries is a cause of action of the sudden provocation. And this Supreme Court judgment also said that the two close clap each other, then this happens. This is not a case of one single-handed. So this is the case here, it is happened. And entire my position is I try to place before this honorable court, this is a case of sudden provocation when the basically husband and wife, when wife or husband put a sentimental words that hurt a lot, and it's happened, sir. That is my humble submission before this honorable court. It is a case of 304 exception case. It is not a case of kill to murder, and it is a PW3's witness with cease of depose. Although I admit in the 313 statement, I have not contrasted this case regarding the extrajudicial confession. Now, the procedure of the extrajudicial confession, what manner they have taken, and what is the procedure, whether they have given reflection or not, that is another issue. But so I admitted, I surely admitted that since I have been 313, I have been mentioned. So my humble submission is a case of the 304 part 2. There is no motive, there is no premeditation, and this Supreme Court judgment completely lied. That is my humble submission.
Dr. DN Gogoi, amicus curiae. Also heard MSP Buyan. None additional yes. Hearing concluded. Just submit your written arguments.
Lordship,
When can you submit?
within a week.
But for not.
Lordship, give a date, I'll try.
Tomorrow is Friday. Oh, day after tomorrow. Friday?
Lordship,
Friday.
Lordship. And deeply obliged.
Twenty-three to 26 of supplementary.
No, that's it. Maybe. Lordship, continuing from yesterday, just brief recap.
there are a total
You are
of,
on, you are on.
I'm item number 25.
Twenty-five.
Yeah. Criminal appeal 21/22.
Is a jail appeal.
Jail. Now he is out on bail.
Yes.
Lordship, recapping it, this is a case under section 302, 201, 34, wherein there were 8 accused persons. Out of this 8 accused person, I am representing the cause of 1 person. His name is Mia Hussain. Lordship, I had submitted yesterday, Lordship. His name, the appellant's name comes in the FIR at the charge sheet where the police recommends his name for charges and at the judgment.
1 minute.
Only
Price.
price. Well, Lordship, here what had happened is that the FIR says that the informant was at her home. There was a saki, a lamp was there, and all these 8 accused persons called him outside, the deceased person outside, and in the lamp and the saki, in the dim light, she could identify these 8 persons. This was the story of the informant. But all throughout, all the witnesses, all the prosecution witnesses, apart from the IO, including the IO, and every witness have named only 2 persons, Habibur and Azizur. They are different appellants all. They were the persons, all the extrajudicial confessions that have been taken into consideration by the learned trial court have in there also, only these 2 names were there. All the persons who were the witnesses, only these 2 persons were there. Lordship, my amicus curiae yesterday had read through all the PWs, so I'm not repeating the same thing again because it will be a repetition. Yesterday I read the IO's part. In the IO's part also, there was no mention. In fact, if Lordship just comes to that page here, I'll just bring one line of the IO. Page 35. Page 35.
Yes.
Page 35, from top, 4th line. The names of the accused persons were Habibur and Azizur. So the IO, while he deposed before the court, even then also he had not given my name. Thereafter, Your Lordship, then before going to the judgment, Lordship, I'd like to take to page 55, which is the 313. Page 55, the 313 statement of Mia Hussain. Lordship, the significance of a 313 statement is that the trial court, after going through the evidences, the prosecution witnesses, the defense witnesses, if any, he forms in his mind certain questions which he'd like to put forward towards the accused as to what were the circumstances as you might have done the act. That is the basic idea of a 313 statement, Lordship. The Lordship, if Lordship allows me, I'd like to read the questions of the trial court, because that will be very important to form an opinion as to, yes, Mia Hussain was a person who was involved in the offense, alleged offense. What's the first question? Question number 1. PW1 Mohammed Nurul Islam has deposed at 6 a.m. on 1108. Now, even the judge below has taken the note of the incident to be 6 a.m. at 1108, whereas the incident undoubtedly was of 13/4/2008. All throughout the postmortem report, everything is. So there was a total non-application of the mind on the part of the judge. Rumena Fukan went to his house and said that you and the remaining accused person had called her husband to Romari for discussing the matter of art cutting, but he did not return home till morning. That she saw the villagers and detained Azizul and Habibul. That later on, when police questioned them, they admitted they killed Azibur and buried the dead body at the spot about 1.5 kilometers from the house of Rumena. What do you have to say? Now, Your Honor, the question itself says he has deposed that at time Rumena went to his house. Rumena Khatun went to his house. Now, the question I'm trying to understand, what is the question the learned court below wanted to ask? Depose. Now, if we go to the deposition of Nurul Islam, there is no as such deposition. If Lordship allows me, I can read the deposition, but there is no deposition as such where Rumena Khan went to his house. Now, it was Rumena Khatun was the informant. So the question itself is, what was the idea before it? I asked myself this question, I am failing to get an answer. That's the first question. Second question, PW2 Rumena Khatun has deposed at about 6 p.m. on 4/4/2018. You and the remaining accused called away her husband, Azibur, from house from discussing the matter of cutting, but her husband did not return till next morning. She told the villager that thereafter she informed the PS. The police recovered the dead body and the police recovered the bicycle sandal matter of her husband from the PO. What do you have to say? I'm innocent. Next, PW4. Abdul Qasim has deposed in the morning of 14/4/8. He heard that Azizur was killed. Again, this is a hearsay evidence. The court taking note of a hearsay evidence and asking a 313 question. That being informed, and he saw the police have kept Azizul Habibur detained in the pharmacy of Afzal Khan, and that when questioned, they admitted that they, along with Fakiruddin, Taibur, Rahman, Said Ali, and some others had killed Azizul. Here also, in this question number 3 also, Mia Hussain name is not there. Other accused, other Said Ali, Fakiruddin, these are convicted. Those names are there, but in this question also, my name is not. That question is also not put, whether that name is there. Second, question number 4. PW7, Iqbal Hussain has deposed that the incident took place in 2008, that about 6 a.m. on the day of occurrence after offering prayer, when he was coming out of Masjid, Rumena Khatun told him that on the previous night, Azizul and Habibul called away her husband. Again, no name, my name, from home, and she did not return home till morning. And at that time, many people were there, that they saw a blood-stained shirt, pair of slippers, and a bicycle near embankment. That they brought Azizul and Habibul from the home to the market, and when questioned, they admitted they buried Azibur after killing him, and that Fakiruddin, Abdul Karim, and another person were with him. What do you have to say? Here also, no mention of Mia Hussain. To put Mia Hussain into the another person would be too far-fetched for any criminal trial. PW8, Dr. Matiur Rahman has deposed that on 15/4/2008, he did PM examination on the dead body of Azizur Rahman on BP. This is not relevant. Do you have anything to say in connection with the incident? I am innocent. Will you adhere to it? No. Now, this was the 313 statement. Now, Your Lordship, now, as I read other 313 statement also, the questions were verbatim same. There is no specific questions. There are 7 different people are there. 8 different people have been accused of a murder. All 8 cannot be at the same circumstances, same thing. The questions ought to have been different. But the learned court below, in a mechanical approach, without application of mind, the biggest proof, the first proof that there was no application of mine is the first question when the learned court below asks that on 1/1/2008, the incident is of 13/4/2008. Had it been not 13/1/2008 or 13 or maybe a 1/4/2008, maybe some typos. 1/1, you are talking of something else. The learned court below has taken consideration of this fact. This is my humble submission regarding 313. But you may be pleased to go to the judgment thereafter, which is at page 68. Lordship, should I read the whole judgment?
How long is it?
Not, it's about 15 page, not 15, sorry, 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 14 pages.
Read the relevant ones.
11. Lordship, the first part was the story of the prosecution, which has been reiterated already. So that I'm skipping. In Lordship, here also, it will be important. It's basically the same thing that has been told, but when the prosecution story has been narrated, the first paragraph 1, if I read just paragraph 1, where the prosecution story, even the prosecution story taken note by the Honorable Trial Court, there also my name will not be there. The prosecution case as unfolded by the FIR is that on 14/4/2008, Rumena Khatun lodged an FIR with the Ding police alleging that there arose some dispute with them with accused Fakhruddin Ahmed, Abdul Hakim, Abdul Karim, Abdul Rahim, Muhammad Habib, Muhammad Aziz, Mia Hussain, and Said Ali. This is about the FIR. And after dispute, the accused have been looking for an opportunity to cause damage of them. Now, this is a new line that has been inserted. It is further alleged that on last 13/4/2008 at about 7 p.m., the above accused person formed an assembly, came to her house and called her husband Azizur Rahman, telling that they have some important conversation with him. Now, regarding this forming of an assembly, in the charge sheet also there is no mention about it. Lordship may peruse the charge sheet for, if Lordship allows me to go to part where there is I have not found it. So Lordship may go to the charge sheet, it's 102. I'll just check, Lordship. There is no question, no mention of any unlawful assembly. Page 102, relevant page is 106. The case in brief is that on 14/4/08, Mustafa Rumena Khatun, wife of such and such, resident of such and such, lodged and written Ezehar with PS alleging that around 7 p.m. her fellow villagers, such and such, all the names are being given, called away her husband, saying that they had to talk to him, and he left on a bicycle, and she recognized the accused person when she held the lamp when her husband was leaving. Now, that is the line that is being told in the charge sheet. The learned court below brings in the word unlawful assembly. Unlawful assembly is an offense which has to be proved in a different way, and they are not accused of an unlawful assembly as well, even in the charge sheet. Anyway, Lordship, going ahead, page 68, again moving back to page 68, and called her husband Azibur, telling that they had some important conversation with him. At that time, her husband took out his bicycle. Then she made the path light with an earthen lamp, Saki, and with the light of the earthen lamp, she recognized the accused person. Where are these words coming from? But for the whole night, her husband did not come. As such, in the morning, she intimated the matter to the people, and then people caught and asked Muhammad Habi and Azizul Haq. Muhammad Habi and Azizul Haq. Again, these two names. And then the people caught, who in turn admitted that they have killed her husband and buried him, subsequently accused Muhammad Habi and Muhammad Azizul were handed over to police, hence the case. Now, these two new lines, lighting of the whole, where is, it's not there in the evidence. Lordship, then we can directly go to the points for determination, which is at page 69. 5, page 69, point number 5.1. Whether the accused persons on or about D13/4/2008, in furtherance of common intention, committed murder by intentionally or knowingly causing the death of Hajibur Rahman, the husband of the informant, and thereby committed an offense punishable under section 302, 304 of IPC. Now, the accused persons, whether the point for determination was whether there was first a common intention. Common intention, the people has to be, all the people has to be together. And second is that there was death cause. Second point of determination, whether the accused on or about the same day, time and place, in furtherance of common intention, knowing or having reason to believe that the offense of murder of Hajibur Rahman had been committed, which is punishable with death or life imprisonment, and buried the body of Hajibur Rahman with intention to cause disappearance of evidence and thereby committed an offense punishable under section 3201, that is disappearance of evidence. Now, discussion, decision, and reasons thereof. Before entering the discussion, the gist of the prosecution evidence is laid below. PW Muhammad Nurul Islam has deposed that he knows the complainant Rumena Khatun, who has filed a written ezahar with the Ding police station on 1/1/2008 for the death of her husband. On that day at 6 a.m., the informant Rumena went to his house and informed him that the accused person present in the dock took her husband to Romeri village for discussing about the matter of earth digging. She reported that husband was called out by the accused. Now, it was called out by, she deposed that it was called out by the two accused person. Now it is saying accused. Which is the accused? There are 7 accused person, and he did not return till morning. She informed that she had already reported the matter to other villagers and she requested him to go to her house. Accordingly, he went there, and on the way, while he reached the market, he saw that some villagers caught hold of and cordoned accused Hobi and Azizul. When he saw this, he immediately informed Ding police station over telephone. Then OC of Ding police station came over and took over the above 2 persons. When police interrogated them before public, they admitted that they killed Azizur Rahman. The above named 2 persons made statement before the investigating officer that they concealed the dead body on the ground in the neighboring shore, situated at a distance of 1.5 kilometers away on the northern side of the house of complainant Rumena Khatun. After hearing the statement of the accused, they, the villagers, along with the police and the above named 2 persons, went to the site where the dead body was buried, and on being shown by the accused the exact spot, the villagers cordoned the area along with the accused. The police officer told them that he would inform the magistrate and they should await their arrival of the magistrate. After a while, the magistrate arrived. The place was dug with the help of the accused Hobi and Azizul. Then the dead body was dug out from the ground. Exhibit 1 is a scissor list and Exhibit 1:1 is his signature. Thereafter, the police and the magistrate took away the dead body as well as the accused. PW2, Rumena Khatun has deposed that the occurrence took place on 14/4/2008. Now, if we go to PW2, which is at page 12, it is said 14/4. But the FIR says is the incident is of earlier. Page 12 is the occurrence took place on 14/4. Today, I think the court is rising at 1 p.m. instead of 1:15. That's what. Mary. On the day of occurrence at around 6
No, one.
On the day of occurrence at around page 71, Lordship, second line. On the day of occurrence at around 6 o'clock in the afternoon, her husband Ajibur was taken away from their house by the accused persons with the information to her that they had a discussion regarding earth cutting towards Raumari. Accordingly, her husband went with the accused person. She was waiting in her house, but her husband did not return till morning. During night hours, some co-villagers came to her house and she informed them that her husband has not returned. She informed about the fact to Asghar Ali, one of her uncles who has already expired. In the morning, she informed the co-villagers, the BDP and the village admin Nurul Islam PW1. Then she went to the police station at around 7:30 a.m. The police came and the dead body was recovered. Police detected the bicycle, sandals, muffler of her husband at the place of occurrence. She was also present there at that time. The police were waiting, and when the magistrate appeared there, the dead body was dug out from the spot. The dead body was of her husband's dead body. The dead body was taken by the police for postmortem examination. Later, the dead body was handed over to them and they cremated the dead body as per her rights. The place of digging the dead body was spotted by accused Hobi and Azizul. Exhibit 2 is the FIR and Exhibit 2-1 is their signature. Again, there is no mention of my name. PW3 Jahid Ali has deposed that the occurrence took place some 3-4 years ago on the day of first Bahag. After morning prayers at Masjid, he was sitting in a tea stall, and at that time, some villagers, along with VDP and Gaubura, came there, informed him that one Ajibur deceased was called on by the accused last night, and since then he has been missing. They also told him that some articles like comforter, a pair of slippers, and a bicycle was lying on the riverbank. Then he, along with others, went there and found the same. Then he saw the accused Azizul and another Habibur was altercating with villagers when they were asked by the villagers to find out the deceased. Thereafter, both of them were taken to the market, and after little interrogation by the villagers and VDP, they confessed before them that they, Azizul, Habibul, Fakiruddin and Syed Ali, there is no mention of my name, killed the deceased and buried the dead body in the char. After some time, the officer in charge of Ding police station, Sushil Datta, arrived there, and along with him, they proceeded to the place where the dead body was buried as led by the accused. Both the accused, Azizul and Habibur, dug out the dead body in front of the villagers and took back the dead body. Police made a seizure list of the articles found in the riverbank, White Exhibit 1, and he put his sign, White Exhibit 1-2 on it. That much he knows. PW4, Abdul Qasim has deposed that the incident took place on last 14/4/2008. On the day of incident in the morning, he was standing in front of his house. At the time, he heard Jahangir that Azizur was murdered and 2 men were caught by the public at Matkula Bazar. These 2 men are Azizur and Habibur. After getting the information, he went there and had seen Azizur and Habibur Rahman confined in the pharmacy of VDB Secretary Afzal Khan. Around 200 people were gathered there. While Azizul and Habibur were asked about the incident, they told, including them, accused Abdul Karim, Fakiruddin, Taibur Rahman, Syed Ali and few others, again no name, had murdered Azibur. While both accused persons were confessing the offense, at the time, Zahid Ali, Javed Ali, Hasmat Ali, Jainal Abidin, Majibur Rahman, Sarkari Gaubura, Nurul Islam, Abdul Qasim Faraji, and many others were present there. Police came there and on being informed, and the accused persons were handed over to police. Police again asked the accused person about the incident before public. Then also the accused person gave the same statement. Police, along with the accused person, went to the place where Azibur was murdered and seized muffler, sandal, and bicycle, which were lying at the place of occurrence. They noticed blood stain in the drain at the place of occurrence. Thereafter, Azizul and Habibur left the police to the place where Azibur was buried. The place was sawed with jute sheets. After coming to of magistrate, it was unearthed and the dead body of Azibur was recovered. Police recorded his statement during investigation. PW5. Afzal Hussain has deposed that he knows the complainant Rumena Khatun and also knew the deceased Azibur Rahman. Deceased was the husband of the complainant. The incident took place on 14/4/2008. At the time of incident, he was in the pharmacy located at 2 number Kandulimari and was a VDP secretary. On the day of incident, while he was coming to open his pharmacy, then Urmena Khat told him that on the previous day at around 8 p.m., Azizul Haq and Habibur took her husband Azibur from their house.
her husband was taken out to bring his wage money, and on that night, Ajibur did not come back to the house. At the time, many people gathered at the bazaar. Thereafter, their VDV men and the villagers went to the house of Azizul and Habibur. On getting them at their house, they brought to the bazaar at his pharmacy and asked for Azibur. Then Azizul and Habibur confessed that they, associated with Kasim Ali and Fakiruddin, murdered Azibur and dug out. Again, no name of Mia Hussain. Thereafter, he informed the police of Ding PS about the incident. After coming of the police, they handed over Azizul and Habibur to police. Police took both the accused person to the place where Azibur was buried. Subsequently, it was told that both accused person took the police to the place where Azibur was buried. The accused person took the police to other side of the dead water where jute seeds were sowed, and they showed the place where the dead body of Azibur was buried. The officer in charge then told that the dead body would be unearthed after coming of the magistrate. When a magistrate came there and the dead body of Azibur was unearthed from the place and the police took the dead body. PW6. Abul Kazem Farazi has deposed that the incident took place in the year 2007. On the date of incident in the morning time, he was in the shop of Matkula. At the time, Rumena Khatun came to the market and sobbingly told the people on the previous night, Azizul and Habibur called out her husband from her house, and thereafter her husband did not come back. Thereafter, they, along with VDP Secretary Afzal Hussain, Abdul Kazim Master, and many people from the market went to Raumari village by embankment route. While they were proceeding by embankment, they noticed on the side of the embankment a bicycle, sandal, and muffler lying, and also noticed blood stain. At that time, Azizul and Habibur came there. Thereafter, the VDP secretary and other people brought Azizul and Habibur to pharmacy of VDP secretary Afzal Hussain Khan. While people asked Azizul and Habibur, they confessed that after they have murdered Azibur Rahman, they buried him at another place. The VDP secretary informed the police, and then the police came there. When police asked Azizul and Habibur, they confessed the guilt, and they led the police to the place where they have buried the dead body. PW6, along with many other people, also went to the place. The place was plowed for sowing jute seeds and in a shore area. Police called magistrate, and after the magistrate reached at that place, the police unearthed the spot and brought out the dead body of Azibur. Police recorded his statement. Here also, no name. As obvious. PW7, Iqbal Hussain Kabir has deposed that the incident was of 2008. On the date of incident in the morning at about 6 a.m. while he was coming from Masjid and after offering namaz, then Rumena Khatun sobbingly told that on the previous night, Habibur Rahman and Azizul called her husband, but till morning he has not returned home. At the time, other people were also present at Matkula Bazaar where Masjid is located. After listening, Rumena, when they asked her husband was called out, then she told her husband was taken towards embankment. People went towards the embankment and noticed one bloodstained shirt, a pair of sandal, and a bicycle. Thereafter, they went to the house of Habibur and Azizul, and on getting them, they brought both of them to bazaar at the medicine house shop of VDP Secretary Farazi. When Habibur and Azizul were asked about Azibur, they confessed that they have buried Azibur after committing his murder, and Fakiruddin, Abdul Karim, and one another were also with them. Thereafter, they informed Ding police about the incident over phone, and the police came there. Habibur and Azizul were also confessed about the incident before the police and told them that they would show the spot where the dead body was buried. Police called the magistrate, and after magistrate came, the dead body of Azizul was dug out from one side of the shore. During investigation, police recorded his statement. PW8, I'm skipping for my purpose because PW8 is the medical officer. Here, obviously, the medical officer has nothing to do about my involvement out there, so I'm skipping this part. Now, paragraph 7. It is the argument of the prosecution case. From the evidence of PW, it is established that deceased was taken out by the accused person. Now, this is a reliance that the learned court below is taking is the evidence of PW2. Now, if the evidence of PW2 is read in isolation, the FIR was the first part which says accused, these were the persons. Now she and the other witnesses, PW7 and PW8, to them, all of them, she has said Habibur and Azizul had called my husband. To all of them. So this
reliance by the court below, this is not a correct understanding of the prosecution case in my respectful submission. Going ahead, the accused Habibur and Azizul confessed before the general public that they, including Fakiruddin, Abdul Karim, and some other person, killed Azibur and buried person. Here also there is no mention of my name. The learned court below took the names of Fakiruddin, Abdul Karim, and some other persons. Now, some other persons cannot be so vague in a criminal trial. It is also the argument of the prosecution that being co-villagers and dealing of work with co-accused person, the wife of the deceased had a clear opportunity to observe and identify his assailant. There was no test identification period. It is an admitted fact. So this statement is something which is personal to the learned judge below. How it is a clear opportunity just because that someone, they are co-villagers and dealing with work, that means a clear opportunity to observe and identify his assailant. It is also the argument of the prosecution that in an instant case, investigation started on the basis of GD entry number such and such dated 14/4/2008. The defense has failed to shake the credibility of PWs. To what aspect? Now, credibility of the PW, whether vis-a-vis me, there was no mention of my name. On the other hand, defense witness does not inspire confidence. Defense case is subsequently manufactured and is a concocted story. Now, defense case is subsequently manufactured and concocted story is, what is the defense case is that which is the concocted story that the learned court below is referring to. In my respectful submission, there is no mention of any concocted story, which is the story. Then the citations are given. Refuting the argument of the prosecution. Now the story of the defense is there, which has been taken consideration by the land court. Refuting the argument of prosecution, learned counsel for the defense has submitted that there is no eyewitnesses. Admittedly, there is no eyewitnesses. The main PW2, the other witnesses, all have PW2 said it. He was called from my house. After that, she had no knowledge. Others, they have said, I have informed them in the morning. And the prosecution version of last seen theory cannot be relied into as evidence of PW 1, 2, 3, 4, and 6 suffers from serious inconsistencies. He further submitted an alleged confession before the police officer at a police station in presence of other witnesses inadmissible as per section 25 and 26 of the Evidence Act. Learned counsel in support of his overall argument relied on the following citation. Now, this is the story which is the word used is concocted story. I ask myself question is what is the story which is concocted here? The defense part. Now let us scrutinize the evidences recorded in the case. Para 9. It is evident from the evidence of PW2 that on 14/4 at around 6 o'clock her husband was taken away by the accused person. The analysis by the learned court below was that on 14/4 at around 6 o'clock it was taken. Whereas the FIR, the charge sheet, all have been saying that it is 13/4. But did not return till morning. As such, in the morning, she informed the matter to her co-villagers VDP and the village headman Nurul Islam. It is also evident from the evidence of PW1, PW3, PW5, PW6, and PW7 that they have been told by PW2 that on the previous night, her husband was taken away by the accused person, but he did not return. Hearsay. Admittedly, hearsay. Accordingly, PW5 informed the police over the phone and subsequently PW2 filed the formal ezhar. Thus, it appears that there is no eyewitness to the incident and the prosecution has relied on last seen theory, extrajudicial confession and leading to discovery on the basis of GD entry to 219 dated 14/4/2018. So, coming under trying to synergize the whole argument of the learned court below or understanding the mind, it is the last seen theory, extrajudicial confession, and leading to discovery.
Continue at 2. Yeah, single bench.
Deeply aware.
Yes.
Yes. Lordship, we left at page 77.
Yeah.
So just as per the learned code below, three parameters which led to the judgment according to the learned code below was last seen theory, extrajudicial confession leading to discovery on the basis of GD entry 219 dated 4/4/2008. Continuing. PW2 in her cross-examination has stated that she could identify the accused with the help of a lamp. The defense also brought on record that the accused are close neighbors adjacent to their house and they are cousins of her husband. In addition to clear look, the accused persons are also neighbors and close relatives of the informant. As such, she has been acquainted with the voice, physique, and nature of the accused person. Now, she is acquainted with the voice, physique, and nature of the accused person. This line is nowhere in the deposition. Further, the defense had elucidated that when the husband of PW2 went out from the house, he was going comfortably with the accused, which affirmed that the deceased on relevant night went with the accused person. So the part was that he went comfortably. Thus, non-seizure of the lamp by the investigating officer cannot make the prosecution weak. Here, the informant is telling that she could identify the accused with the aid of the lamp. Now, the lamp becomes a very vital evidence. The court, to arrive at a conclusion that there was actually a lamp, and by that very lamp, the accused was identified, that had to be before the court. The learned court below was not, the learned judge below was not present at the relevant point of time. He has to gather from the evidence. So I ask myself this question, Your Honor, how this cannot be a important evidence? The very factum, the lamp which identified everyone, that is not before the court. So that means the version of the PW2 is the gospel truth. This is not what criminal jurisprudence is, to my respectful submission, Lordship. Thus, non-seizure of the lamp by the investigating officer cannot make the prosecution weak. PW2 on the next day morning has reported to the people whom she found in her house and in the market about taking of her husband by the accused persons on the previous night. PW1, 5, 6, and 7 also stated in the evidence that PW2 told them in the morning of 14/4/2008 that on previous night the accused person had taken her husband from their house, and since then he has not returned to home. Thus, there is corroboration in the evidence of PW1, 2, 5, 6, and 7. PW3 also in his evidence told that on the relevant morning, while he was sitting in the tea stall, at that time, some villagers along with VDP and the Gaubura came there and informed him that Ajibur, deceased, was called on by the accused person last night, and since then he is missing. Thus, the prosecution has proved that the deceased accepted the call of the accused person on the relevant night and went with them, and thereafter the dead body of the deceased was recovered. Defense in course of cross-examination of PW1, PW2, PW3, PW4, PW5, PW6, and PW7 was not able to elicit anything to discredit the evidences and to disprove the circumstances deposed against them. In the morning of 14/4/2008, PW2 informed the co-villagers, the VDP and the village headman Nurul Islam PW1, and went to the police station at around 7:30 a.m. PW1, PW3, PW4, PW5, PW6, and PW7 also told that they informed about the matter by PW2. All along, there is no dispute to the fact that they are nowhere they were not an eyewitness to the event. Now, as per PW1, while he was going to the house of PW2 at the market, he saw some villagers caught hold and cordon accused Hobi and Azizul. Then he informed Ding police station over telephone. Police came there and took over the accused person. On interrogation by the police, the accused has admitted that they had killed
Ajibur Rahman and concealed the dead body on the ground in the neighboring shore, which is situated at a distance of 1.5 kilometers away from the house of the complainant, Rumena Khatun. Then the villagers, along with the police, went to the site led by the accused Habi and Ajizul. Again, Habi and Ajizul, where the dead body was buried. And after arrival of the magistrate, the place was dug out and the dead body was recovered. Now, as per PW3, after detection of comforter, a pair of slippers and a bicycle on the river bank, accused Azizul and Habibur were brought to the market by the public, and there the accused person confessed before them that they, along with Fakiruddin and Syed Ali, again the name Fakiruddin and Syed Ali, not my name, killed the deceased and buried the dead body in the char. As per PW4, he saw Azizul and Habibur Rahman confined by the people at Matkula Bazar in front of the pharmacy of Afzal Khan, and on asking accused Azizul and Habibur Rahman, told to them that they, along with Abdul Karim, Fakiruddin, Taibur Rahman and Syed Ali. Now this Taibur Rahman is a new entry to the whole story. And Syed Ali and few others have murdered Ajibur. PW4 has stated that at time of confession by both the accused person, Jahed Ali, Javed Ali, Hasmat Ali, Joinal Abidin, Majibur Rahman, Sarkari Gaubura, Nurul Islam, Abdul Qasim Faraji, and many other people were present there. The defense in its cross-examination has not brought any material to show that there were forceful circumstances to the accused person for their confession before the public. This is a statement which is totally contrary to the record. The PWs have stated that there was police, they were gherowed, there were 400 people, 5,000 people. The very sight of, even we assume that there are 200 people, not 4,000 or 5,000 people. The very sight of 5,000 people would be brought any material to show that there were forceful circumstances to the accused person for their confession before the public. I pause myself, Lordship. If this is not forceful circumstances, then what would be a forceful circumstances? Page 18. Page 19, Lordship. Yes. It is not a question that defense needed. The prosecution in their evidence in chief has said this thing. It is not even a cross-examination thing. Second line. When the police interrogated the accused person in presence of the public, both the accused person confessed in similar fashion. It is not a statement given in it has not been brought out through cross-examination. It's a statement given by their own free will. I mean, it is in the evidence in chief. Similarly, in page 26, another witness, page 26, third line. On being interrogated by the police, they admitted their guilt. If this is not forceful circumstances, there is no dispute. All the prosecution witnesses have told that the minimum number of people was 200. Some has said 4,000, some has said 200. Now, assuming for a moment, that means there was a minimum of 200 people surrounding. If that is not a forceful circumstances, then what would be a forceful circumstance? This aspect was totally not considered by the learned court below. Page 78, going to back to page 78. PW5 also stated that on the relevant day, accused Azizul and Habibur were brought to the market in his pharmacy, and both the accused person confessed. Besides them, accused Syed Ali and Fakiruddin committed the murder of Azizul. Who was there? Name of Syed Ali, Fakiruddin, these two names are continuously there. But my name, Mia Hussain, it's not till this part of the judgment, except for the prosecution story, in this part of the, till this point, no mention of my name. Moving on. Now, as per Ding PSGD entry number 219 dated 14/4/2008 at 7:55 AM, the police got the information from BDP secretary of number 2
Kandulimari that a person has been murdered and buried thereafter, and 2 persons has been intercepted. It can be seen that the dead body was recovered by the police not in consequence information given by the accused, rather than police already got the information regarding the murder of a person and his burial. Thus, there is no discovery on the information purportedly given by the accused, and as such, Section 27 of the Evidence Act is not applicable in this case. The trail takes a totally different route. All throughout, it was the case that police came, the informant called up the VDP came, they went to Azizul and Habibur, they took, these Azizul and Habibur took to the place where it was buried. Now, the court below has come to the finding that there was no discovery. Moving ahead. From the evidence on record, it is established that before arrival of police, accused Habibur and Azizul were caught by the villagers and they confessed about the murder of Ajibur. Dead body of Ajibur was recovered by the police in presence of magistrate and villagers. All the PWs have substantiated this fact. Now this aspect is taken into consideration, that all the PWs have substantiated which fact? The fact that it is Habibur and Ajibur. Now the place from where the dead body was recovered is an open field where jute seeds were sowed. The dead body was buried and it was recovered after digging the earth as shown by accused Habibur and Ajibur. And this fact clearly indicates that the dead body was hidden and it was within the knowledge of accused Habibur and Azizul. Again, Habibur and Azizul, not Mia Hussain. From the evidence, the following facts has been established. As per PW2, Rumena Khatun, wife, now pausing here, Lordship, in the PWs, all the PWs have mentioned that there was a case against them. This aspect was totally ignored by the learned court below, which is a vital aspect because they are a witness and they are a witness, assuming for a moment that it is admissible per se, that it will be admissible out there. If they are a witness, then there was the coercion, the police had said what was there. These aspects were not discussed by the learned court below. So moving ahead, as per PW2, Rumena Khatun, that is wife of the deceased, accused person on 14/4 at about 6 o'clock. 14/4, 6 o'clock. Date. 13/4 was the date. It was supposed to be at the point. But anyway, in the afternoon, 6 o'clock in the afternoon. 6 o'clock in the afternoon is a new thing which has been, it's a new to me at least. Took away her husband from their house, telling that they had some discussion regarding earth cutting, but he did not return home. In the morning, PW2 informed the villagers about the missing of her husband, and thereafter villagers caught Habibur and Azizul, and they confessed before villagers about murder and burial of Ajibur, and PW 1, 3, 4, 5, 6, and 7 have substantiated the fact. In the morning, dead body was recovered by the police in presence of the magistrate as shown by accused Habibur and Azizul. It can thus be seen that a chain of circumstances is complete, which is the starting point of the chain, which is the end point of the chain, which has to be deciphered from 1, 2, and 3. And in my respectful submission, reading of 1, 2, and 3, that nowhere points to completion of a chain. Why? Some people are saying 4 o'clock, date is 14, 13, 6 o'clock, 8 o'clock. What is the actual story probably is not known at all. Anyway, now in the FIR, it is stated that quarrel and dispute existed between the accused persons and the complainant side. In her cross-examination, PW has stated in her cross-examination that the accused person have some dispute with their husband, which indicates motive of the accused persons. From the evidence, it is thus established that none other than the accused persons who killed Ajibur, and in order to cause disappearance of evidence, the accused persons buried the dead body of the deceased. There is some discrepancy in the testimony of the PWs, but they are bound to occur as each PW will narrate the incident in their own language. Pausing here, Lordship, if an incident is narrated in its own language, discrepancy will not be there. In alien language, if someone deposes in an alien language, the discrepancy might have been there. It's the other way around, in my respectful submission, Lordship. And this discrepancy do not affect the root of the prosecution case on material point. Criminal, when a judgment is written, it cannot be on a vague
statement as to there is, it does not, these discrepancies do not affect the root of the prosecution. Now, what are the discrepancies which actually are discrepancies which is against the accused, and this could be overlooked? That's nothing has been discussed here. Postmortem expired and the evidence of PWA substantiated fact that death of Ajibur was caused due to injury sustained by him. Now, injury was sustained by him. How? What was the murder weapon? What was, how it was injured? What is the kind of injury? Nothing has been discussed here. Though I am not on that point because here I am nowhere mentioned out there. I could not have known as how the whole thing happened. Anyway, considering the facts and circumstances of the case and evidence and materials on record, I have arrived at a finding that the accused person in furtherance of the common intention have caused the death of Ajibur and buried his dead body to cause disappearance of his evidence. Now, this is the finding sentence. I am not bothering you also to reading the whole thing. Now, Lordship, reading the whole judgment, the circumstances, the role of Mia Hussain, how he was there, from where the court got the information that Mia Hussain is part of the group of people. Now, the word used is unlawful assembly, but it cannot be an unlawful assembly, but the group of people who allegedly was called by, the deceased, where it is not a single, even Rumena Khatun, the PW.
It is not unlawful assembly. It is forming an assembly.
It's a forming an assembly. It's not an unlawful assembly. It's a assembly, but in that assembly, where even the PW1, 2, in not a single one has told that I was a part of that assembly. Lordship, I would like to reiterate and take again to page number 92. Though that cannot be taken to, since the 161 statement, page number 92, 93, 94, 95. This is probably the story which had happened. In that story also, there is no mention of my name. Page 92. This is 161. 161. This cannot be looked into it, but this has been made an exhibit. That's why it is before your own. So I am placing my reliance here by virtue of that fact, though it cannot be looked into it. But since it has been marked as an exhibit, because this is marked in the exhibit in the judgment as well. So the story, in this story also, if I read, first part I'm skipping, I have this much to say that for some days, Habi, page 92 I'm reading, Lordship. Habi, Ajibur, Fakhruddin, Syed Ali, Abdul Barek, etc. And I were doing hard art cutting work at village Romari. Fakhruddin, A. Qasim, Syed Ali, A. Hakim have all disputed Ajibur. This has to be taken note of. Here, what he was saying is that there are a lot of people that were doing earth cutting. There's no point going into this. We can rely on this.
But it is exhibited. That's why I'm saying. But just to give an idea as to, I ask myself this question as to why, why is my name in the FIR then at all? Question: if I am not there, if nothing is, why is my name there? So why it was given in the first instance? The story is this, that actually it was Habibur and Ajizur who had gone there to call the deceased probably. And when they were caught, the police gave these names. Now, police during the FIR was written in the PW2 clearly said that it is written by the police station. First, she says it is in the police station. Then she said it's a Ding Bazaar. We don't know who has written the FIR. That is the story of the prosecution. So now, what had happened is that these people were working. So what they did is that they asked who is Abdul Barek, who is Syed Ali, and my Mia Hussain was there at the elevator. He was also taken away. Otherwise, not even a single PW, including the informant, not even a single whisper. And to bring me into the ambit of some other persons which have been said, that will be too far-fetched, and this is what the criminal jurisprudence says is, first of all, to the proof, the probative value of the proofs, the evidences has to be beyond reasonable doubt. Here, my case is not even beyond reasonable doubt. There is no evidence at all. the prosecution needs to show at least one evidence against me so as to be, I should be convicted of 302. That I have not brought any judgment because benefit of doubt. Yes, if there was any evidence, that evidence I will bring. I will try to prove that there is a benefit of doubt that evidence cannot be taken. Here, my case is that there is no evidence at all against the appellant. The only thing, and even the judgment, the learned court below, in a mechanical, why the judgment is in a mechanical process is simply it can be understood when the judgment writes the date as 1/1/2008. It was a mechanical process. It was probably it was preconceived that I have to give a conviction. So that this is a thing, and these are the names. The 313 state questions, all the questions are identical. All the questions are verbatim. Circumstances can't be same for all the accused. Some prosecution witnesses will say against ABC this circumstance that has to be put in 313. I have demonstrated the 313 against me. Nothing, not a single line which shows that I had done this. I mean, the offense has been committed by the appellant. So, concluding here. Concluding my argument, Lordship, here the appellant ought to be acquitted because none of the prosecution witnesses, none of the evidence that has been brought on record. And to that point, Your Honor, Exhibit 5 and 6, which Your Honor has said that 161 statement, even though it is exhibited, the question has to be taken whether it is a legally admissible evidence or not. That has to be gone into it. So that even that, if that is also taken into account, assuming all extrajudicial confessions it is legally admissible, assuming Exhibit 5, 6 are admissible, all evidences are admissible. Assuming for a moment without admitting, there is no evidence on record to convict the appellant. This is my respectful comment. I reserve my reply after the PP gives it.
My pleasure, Lordship.
You are
Lordship, I am for two person. One is Azizul Haq and Sahid Ali. Total 6% convicted, my lord. Out of the 6, the item number, my lord, is the last item. Item 26, my lord. The appeal was initially, my lord, jointly, and subsequently it was separate, my lord. And item 26 for 2 accused person, that is appellant Azizul Haq and Sahid Ali. I am for Azizul and Sahid Ali. My learned friend already, my lord, the facts already has been elaborately explained before the Honorable Court, my lord. The case is that, my lord, that total, my lord, the 9 numbers of PW was examined. So, yes, ma'am, including the IO and doctor. And here, PW2 is the informant in this case, ma'am. And she is the wife of the deceased man. And the learned trial court, my lord, relied, my lord, at the time of pronounced judgment and considered that on the last scene theory and extrajudicial confession and leading to the discovery, because the informant's husband was found out after digging out and said that my husband was called on, my lord, in FIR mentioned that, my lord, the 13/8, but, my lord, in the court, my lord, when she was examined, she stated that, my lord, 14. In FIR 13/4/2008, in the court when she was examined, she stated that 14/4/2008. That means the contradiction, the date of incident, my lord. And, my lord, she stated before the court, my lord, that this 6 persons' name is mentioned, even then, nowhere mentioned, my lord, about the confessional statement of the accused person. PW1 and PW2 nowhere stated that I was present when the people detained the Azizul and Habibur. They have confessed before us. PW1 and PW2 nowhere mentioned about the confession. So the statement of the PW is not corroborated, because out of 7, PW1 and 2 nowhere mentioned the extrajudicial confession was made by the Habibur and Azizul. PW1 nowhere mentioned. And PW2, the wife of the deceased, she also not mentioned about the confessional statement. Malat, some of the PW stated that the police got the already information that Sandal and Malat, bicycle
Just
and
1
muffler.
minute. Just 1 minute.
Yes, ma'am.
You are appealing for
I am
Shahid
for Malat Azizul and Sahid Ali.
Azizul and Said.
Yes, madam. So here stated that 2 persons detained by the public, Azizul and Habibur, and they have confessed. They, along with the other co-accused, committed the offense. That is her case, madam. In fact, she stated in paper book 8 and 9, the statement of the PW1, my lord. PW1 nowhere mentioned about the extrajudicial confession, madam. Single night not mentioned here. Next, my lord, PW2 and my lord, PW1, another thing is, my lord, there, page 10, my lord. I was reported by the informant about the incident on 2008. PW1 saying before the court that the lady, the informant, wife of the deceased, informed him on 2008. So perhaps the PW1 is not well known about the incident, my lord. Is a doubt, my lord? Somehow he was managed and came to the court and become the PW1, my lord. Now, my lord, the page 12, my lord, that is PW2. Here also, my lord, I am repeating that nowhere mentioned about the extrajudicial confession on the road. Just relevant portion I am reading, my lord, because my learned friend already stated. Here, my lord, in the page 12, the second line, the occurrence took place on 14/4/2008. In the FIR, she stated that 13/4/2008. And my lord, page 15, PW3, my lord. Here, my lord, just on relevant line I'm reading, there I saw that the accused Azizul and another Habibur was altercating with the villagers when they were asked by the villagers to find out the deceased. There was altercation, madam. So the question of extrajudicial confession is not arise at all here, because when altercating is going on, it is the force, madam. Is 15, my lord. My lord, that 1, 2, 3, 4, 5, 6, 7, 8 line, my lord. Just relevant, my lord, line I am showing the honorable court, my lord. So the PW3 clearly, my lord, stated that there was a altercation between the villagers and 2 persons detained by the villagers. It was a force, man. So the confession does not arise here, man. Next, my lord, the page 16, my lord, 16. Page 16, my lord, the approach. I was not examined by the police. Very vital. The person become the witness in a case, my lord. The police did not examine. I was not examined by the police. As such, any statement recorded in my name is not my statement. Whatever he stated under section 161, that was not taken from him. the investigating agency himself recorded from their own, my lord. I do not know how and why whom the deceased was killed. In clause PW3, my lord, clearly says that I do not know how and by whom the deceased was killed. So the PW3 has no value, my lord. His evidence has no value, my lord. Because initially police also did not examine him, directly come to the court, my lord. And since a case of police investigated case, my lord, before framing the search sheet, the duty of the investigating agency to record the statement of the witnesses, my lord. On the basis of statement, police will complete the investigation. But here, my lord, police did not done that one, my lord. Next, my lord, kindly turn to the page, my lord, 19, well. Page 19, my lord, that in cross, my lord, in cross second line, my lord, the police did not record any statement when the accused person confessed that they would show the place. Because if any confessional statement recorded by the police, my lord, should have present the some witness, man. That witness, the PW4 saying that the police did not record any statement when the accused person confessed that they would show the place. Therefore, well, the confession is not value here. Man. Next, my lord, page 20, my lord. Page 20, my lord, that last paragraph, my lord, I am reading, my lord. I saw around 500 people outside the pharmacy. Some, my lord, PW saying that 5,000, 4,000. And this PW, my lord, saying that 500. I did not see if the public had assaulted the Azizul Highway, that part gun. Having seen the muffler, sandal, bicycle, and blood at a place about half kilometer away, some people requested the police because the leading part will not arise here. Because the learned single judge, my lord, the district judge, my lord, when passed the order, in his judgment, he mentioned that the accused person lead to recovery the dead body. But here, it is very much clear that PW4 saying that having seen the muffler, sandal, bicycle, and blood at a place about half kilometer away, some people requested the police to visit the place. Where is the leading? Because prior to the visit the place, police known the incident from somebody else that some, well, the muffler and sandal bicycle is lying. So the leading by the accused person has gone well. As per the requested the public, police visited the place. Police visited the place as per the request of the public, not leaded by the, well, appellant. Next, my lord.
Come to page 19, there it is, the leading
This is 19, my lord.
to discovery. The first para.
My lord, it was sheep, my lord, but in cross already, my lord. I am saying the cross, my lord. Because if a person is stated in something in sheep, my lord, and cross already, my lord, overruled. In cross, my lord, he admitted. The public requested the police, therefore the police visited the place, my lord. And in the meantime, they are detained with the police, my lord. Definitely, police will take them to the place, my lord. It does not mean that they have given the idea that I have buried the dead body and go with them. It does not arise here, my lord. So, my lord, the confessional statement and leading part not established here, my lord. The PW5, my lord, the PTB secretary, my lord. My lord, my lord, here, page 22, my lord, that third para, my lord. Police did not record statement of any accused or witness in between the time of making confession by the accused person and the time of recovery of the dead body. My lord, 161 statement of my lord, Abi and Azizul, the police exhibited, my lord. But it was, my lord, written by the police himself, my lord, because it was not prepared and it was not recorded at the time of, my lord, confession was going on. So this line, my lord, the 161 statement which exhibited, my lord, that has no value, my lord. Because when police will record any confessional statement, should present some, my lord, independent witness there, my lord. Otherwise, every police can write, yes. So there's no value. Only police is confessional statement. Before police, confessional statement will get value that time when other witness corroborate. My lord. I will show some judgment also, my lord. Just factual I am going, my lord. The police did not record statement of any accused or witness in between time of making confession by the accused person and the time of recovery of the dead body. Police did not write anything regarding the confession of the accused persons before police. Now, my lord, the next page 23, the second paragraph, last line, about 400, 500 people gathered at the place of occurrence. Well, these are also, my lord, very contradiction, because in incident, it may be something different, but where is 50 or 60 and somebody says 4,000, 5,000, the person was present or not, it is a doubt, man. The person who stated before the court, whether he was present in the incident or not, it is doubt, because this much difference may not be. Next, my lord, after exhuming the dead body, police wrote something. I did not put my signature on that paper as witness, and they were not make the witness when the dead body was recovered. Next, page 24, my lord. Page 24, the PW 5's, my lord, Croce, he stated that getting the information of the muffler, sandal, blood lying there, the police went there. At that time, accused Azizul and Haibur were also with the police. So earlier got the information from other persons that sandal, blood, and muffler bicycle were lying near the embankment, and accordingly police visited the place. So leading part is not present here. My lord, next page 25, my lord, PW 6. My lord, from bottom, 4 line I am reading, my lord. While passing along the embankment, we saw a bicycle, a pair of sandal and muffler lying at the side of the embankment. We also saw the blood there. Then Azizul and Haibur also came there. BTP secretary and other member of the BTP brought Azizul and Haibur to the pharmacy of BTP secretary. Next, my lord, kindly turn to the PW 7, page 29, my lord. Just relevant portion I am, my lord, showing the honorable court, my lord. My last paragraph, page 29. Police did not record the statement of me and other witness present in the room when Habibur and Azizul confessed before the police. No statement was recorded, man, that they had buried Azibar's dead body and that they would show that place. It was not recorded by the police. The place where short sandal bicycle were recovered is about 1 kilometer away from the place where the dead body was buried. I did not see the blood-stained short sandal and bicycle properly and did not notice any special mark of identification mark. Such things are available in every household, my lord. He's saying that such type of things is available in household of other person also may use. So it may not be the article of informant's husband, man. Next, my lord, the doctor's PW8, my lord. My lord, as per medical report, my lord, injury was in the body, but no weapon was recovered, my lord, from the possession of any accused person. That is also a vital matter, because when the accused was under the custody, could have been recovered, my lord, if really they are involved the incident. My lord. And my lord, the deposition of my lord, PW9, the IO of the case, my lord. My lord, page 36, my lord. My lord, third paragraph, my lord, I am reading. On the basis of the GD entry, I visited the place of occurrence. I did everything that is going to Matikula Bazaar, taking the accused person into custody, preparing the sketch map at the embankment, seizing the items, examining the dead body, holding request on the dead body, and sending the dead body for the post-mortem examination on the basis of GD entry. I did not send accused Habibur and Azizul to the court for getting their confessional statement recorded in connection with their confession and their assertion that they would be able to produce the dead body that day. The IO himself saying that I did not take any step to send them before the court for recording their statement before the magistrate under section 164. It was also not done. I did not record the statement of the independent witness at the time when the accused person said that they would show the place where the dead body was buried. Very important, man. The IO himself admitted. I did not record the statement of the independent witness at the time when the accused person said that they would show the place where the dead body was buried. IO himself admitted. Next, my lord, I had sent the dead body to the court for postmortem. I did not see the bicycle in the court today, which was seized by Exhibit 1. That bicycle also not placed before the court. IO himself saying, well, I did not seize the lamp in the gleam of which the wife of the deceased recognized the accused person. It is very vital because the conviction given on the basis of circumstantial evidence, no eyewitness at all in this case, my lord. So the circumstantial evidence, she stated that she identified the accused person when called her husband in the gleam of the my lord, of a lamp, my lord. Taking the help of a lamp. That lamp is very important. What type of lamp, my lord? Whether it is possible using such type of lamp in village area, can a distance person can identify. That I also did not done. Next, my lord, the 313, my lord, page 43, my lord. But relevant, my lord, question here, page 44. I am relying, my lord, that PW2, the informant, wife of the deceased. The PW2, Muhammad Swanso, has deposed that at about 6 p.m. on Swanso, you and remaining accused person called away her husband from home for discussing the matter of earth cutting, but as per husband did not return home till the next morning, she called the villagers that thereafter she informed the PH. The police recovered the dead body and the police seized the bicycle, sandal and muffler and her husband from the place of occurrence. What do you want to say? Here that question, my lord, was not put that you have committed murder. The husband of the PW2. Nowhere put that question, my lord. Because in 313, my lord, in which ground, my lord, the conviction will given, my lord. the directly question may be put because on the basis of which statement the conviction has given. The circumstantial evidence arising out from the PW2 matter. So PW2's question was put. That is not mentioned here, madam. And my lord, page 47, do you have anything to say in connection with the incident? My lord, they have denied that I am innocent. The evidence is false. I am not involved with the murder of Hajibu. And next, my lord, Sahid also, page 48. I am for Sahid also, my lord. So regarding Sahid also, my lord, the question, same question, just name has been changed. And question was put same way, my lord, but not mention that you have killed the husband of the PW2 man. Now, my lord, that 161, page 92 man. Page 92, my lord, the statement of Azizul Haq, it was exhibited, but already I have, my lord, found that other PW stated that no statement was recorded before the witness man, and it was prepared himself, the IO man. So it has no any value, my lord. That is story prepared by the investigating agency man. Now, my lord, I am relying some judgment, my lord, the honorable court. It will be open. Well, the very recent judgment, my lord. The circumstantial evidence, very, my lord, every link in the chain of the circumstances necessary to establish the guilt of the accused must be established beyond reasonable doubt. All the circumstances must be consistently pointing toward the guilty of the accused. For a 10 mile. Paragraph 10 mile, I am reading. The present on is a case of circumstantial evidence, as no one has seen the commission of crime. The law in the case of circumstantial evidence is well settled. The leading case being Sharat Birdisant Sharda versus State of Maharashtra. According to it, the circumstances should be of a definite tendency, unringly pointing toward the guilty of the accused. The circumstances taken cumulatively should form a chain so complete that there is no escape from the conclusion that within all human probability, the crime was committed by the accused, and they should be incapable of explanation on any hypothesis other than that of guilty of the accused and inconsistent with his innocence. The said principle set out in the case of Sharat Birdisant Sharda has been consistently followed by this court. In a recent case, Salendra Rajdeep, Parjbhan and others, state of Gujarat, this court observed that in a case of circumstantial evidence, law postulate twofold requirement. Firstly, every link in the chain of the circumstance necessary to establish the guilt of the accused must be established by the prosecution beyond reasonable doubt. And secondly, all the circumstances must be consistent, pointing out only toward the guilty of the accused. We need not burden the judgment by referring to other judgment, as the above principles have been consistently followed and approved by this court time and again. My lord, the judgment is covered my case, my lord. And my lord, In case of circumstantial evidence, motive has an important role to play. It is an important link in the chain of circumstances. The basic link in the chain of circumstance start with motive, then move on to last scene theory, recovery, medical evidence, expert opinion, if any, and any other additional link which may be part of the chain of the circumstances. But the principle of corpus delicti, non-recovery of the corpus, would have relevance in considering the link of chain of circumstances. There are 16, my lord. And extrajudicial confession also here, my lord. The extrajudicial confession is a weak piece of evidence, and especially when it has been retracted during the trial, my lord. It requires strong evidence to corroborate it, and also it must be established that it was completely voluntary and truthful, my lord. But here it is not voluntary, my lord, because they were detained, my lord, and altercation and assault and threatening was going on there. Next, my lord, regarding the extrajudicial confession, my lord, another judgment, my lord. The present, my lord, the Honorable Chief Justice of India also here, my lord, that extrajudicial confession is a weak kind of evidence, and unless it inspires confidence or is fully corroborated by some other evidence of cleansing nature. Yes, ma'am. Here discuss paragraph 11 and 12, ma'am. Paragraph 11, I am reading it. At this juncture, it may be noted that as per section 30 of the Evidence Act, when more persons than one are being tried to jointly for the same offense, and the confession made by one of such person affecting himself and some other of such person is proved, the court may take into consideration such confession as against such other person as well as against the person who makes such confession. However, this court has consistently held that an extrajudicial confession is a weak kind of evidence, and unless it transpires confidence or is fully corroborated by some other evidence of cleansing nature. Ordinarily, conviction for the offense of murder should not be based only on the evidence of extrajudicial confession, as held in case state of MP through CBI versus Colton Mullah and others. The extrajudicial confession made by the co-accused could be admitted in evidence only as a corroborative piece of evidence. In absence of any substantive evidence against the accused, the extrajudicial confession allegedly made by the co-accused loses its significance, and there cannot be any conviction based on such extrajudicial confession of the co-accused man. Here, my lord, two accused persons before your lordship. One, my lord, their claim that confessed, and other was not present. He was the co-accused. Sahid was co-accused, and Azizul was present. They are saying that Azizul confessed. And my lord, then our High Court, my lord, another judgment, my lord, that section 302, 301, murder, application of evidence, death of victim due to homicide injury, no eyewitness to the occurrence, accused leading the police to recover the dead body. Recovery made in presence of magistrate. No statement of the accused leading to the recovery was recorded nor proved. But it is applicable in my case also. The trial court convicting the accused, holding the admission of guilty of the accused before the police as having the effect of the corroboration. Recovery is not one made under section 27 of the Evidence Act. The confession part of the statement of the accused is inadmissible under section 25 of the Evidence Act. Conviction and sentence set aside appeal allow. Paragraph 20, 21, 22. Here also, my lord, the lady was not clear because police already got the information from other source that sandal bicycle is lying there, and police of their own will were there because they are in their custody. Therefore, brought them. So, my lord, this case is, my lord, totally case of acquittal one. Circumstantial evidence, extrajudicial confusion, and leading part. The learned trial court relied on that 3-point point, and all the point is absent here. So no case is picked out under section 302 against the appellant. So my humble submission, my lord. And another judgment also our High Court, my lord. It was the Zale appeal, my lord. Here also, my lord, that regarding confession, my lord. The head note is not here, my lord, because I have taken it from computer or internet. Recent judgment of the our High Court. Here also acquitted, my
Para,
lord. Here para 24. Para 26, 27 is relevant, my lord. 8, 26, 27.
para,
Para 8, 26, 27, ma'am. Para 8. Para 8, ma'am, the learned amicus curiae accordingly submitted there was no eyewitness to the crime, and as alleged statement made by the appellant, the police is not admissible as evidence. The learned trial court erred in convicting the appellant under section 302 IPC. And next, 26, 27 also, my lord.
yes.
My lord, Azizul Haq is, my lord, in jail, my lord, and Syed Ali is on bail, man. Syed Ali on bail, my lord. The Honorable Court allow his bail, my lord. So, my
You are in jail since?
my lord, 31, my lord, 13/5/2019. 4 years, 17 days today.
And Shahid?
Syed, my lord, released on bail. My lord, the bail order dated, my lord, order dated 26/5/2020. He's already, my lord, released on bail, man. Syed is on bail.
Okay.
So my humble submission, my lord, may consider the case, my lord, because it is not the case of 302 against the present appellant, my lord. So I Hope my lord, the honorable court will consider that they will acquit in this case, my. And my senior counsel, my lord, he is present, he is argument. Obligement.
Yeah, Anuddin, isn't it? Oh, you.
And Uddin, my lord. My name is not for that. And Uddin.
May it please your lordships. My lord,
You are in?
I am item number 24. Item number 24, I am representing two of the convicts, 2 and 4. That is Abdul Hakim and Abdul Rahim. Who are on bail now.
Oh, you're on the bed.
I am on the bail. Now, Lordship has seen the evidence part of all the witnesses. My learned friends have placed it. Here. Firstly, Lordship will find there is no evidence what the name for conviction. So for my clients are concerned, my appellants are concerned, there is nothing absolutely. Save and accept a particular statement made by one of the accused persons before the police under section 161 TRP, which has no legal value. Without going into the aspects of whether the case is founded on multiple FIR or that there is no eyewitness at all, there is no circumstantial evidence even. That finding based by the learned trial judge is on the basis of some extrajudicial confession, which also falls through because that could not be substantiated in law. I have seen in certain part the learned trial judge wanted to say that there was a statement leading to discovery. Therefore, the two persons represented by my learned friends, they were this Azizul and Habibu. They were sought to be convicted on that basis, that there was a statement. But my lord, in my submission, there is no statement under section 27. Therefore, there could not have been a ground on that count also to convict them. Just to give a glance, Lordship has seen the whole evidence. Lordship has meanwhile shifted the whole evidence. Kindly come once more. Allegedly, the occurrence took place on 14/4/08. First information report.
FIR says 13/4.
Reported on, yes, I'm sorry. It was reported on 14/4. It was reported on 14/4 at 3 p.m. Kindly note this at page 1 of the paper book. Page 1 of the paper book. My lord, I'm sorry, I'm not keeping well that way. So
We can take it up tomorrow.
we can take up tomorrow.
Yes,
If not, it is for your lordship.
better. Stop with. hurt Mr. N. Barrow, learned amicus curiae in criminal appeal jail 94 of 2019. Mr. R.J. Das, learned counsel in criminal appeal jail number 21 of 2022. Mr. Enuddin, isn't it? Learned counsel in criminal appeal jail 22 of 2022, as well as Mr. K.K. Mahanda, learned senior counsel, assisted by MS
And paper.
M. Begum, N. Begum in criminal appeal 414 of 2019. 13th part. Please for further hearing again on, you want it tomorrow or day after? You want?
Be on Friday. As part third, it will come, my lord.
On 2nd June.
Please, sir. Thank you. Or it may be, my lord, taken up tomorrow also. I have no difficulty otherwise.
You'll have no problem.
My lord, problem is processing for last about 1 month. I am not keeping well. But then gradually I'm trying to recoup myself. For last 2-3 days I am coming. And therefore, I cannot exert myself much, but then slowly I will place the matter. That is my health condition.
So you want it tomorrow?
No, because I'm told that your lordship will be, his bench will be having sitting on till Friday, or I do not know whether.
Only till Friday.
Lordship,
Only till Friday.
only till Friday. So since the lordship has been taking the trouble of hearing the whole matter, it will be finished and lordship may process that.
Then tomorrow, tomorrow's date, 1st June.
I am.
Seventeen.
Can you complete today? By 4?
It can be completed today itself, right?
9 witnesses are there. 2 eyewitnesses. 3 eyewitnesses are there.
Lordship, may I appeal? So, Lordship, it's a jail appeal and conviction is under section 302. And as per FIR, that appellant is alleged to kill his wife in his own home at about 10 p.m. in the night. An FIR was lodged by the mother of the deceased. But here, from the judgment of the trial court, it appears that while convicting under section 302, the trial court has relied upon the deposition of PW2 and PW5. Now, apart from these two witnesses, PW7 is also relevant and has to be discussed. But rest of the witnesses are not eyewitnesses. So, to save time, these witnesses can be skipped. Anyway, Lordship, first witness is
We have FIR.
FIR is at page 4, and it is lodged by mother of the deceased. And here, simply she stated, I have the honor to lodge the against so and so. Yesterday on 30/10/16 at about 10 p.m., the above accused had tortured inhumanly to my daughter, namely baby Telipathar, aged 30, who is the wife of the above accused, and injured her head and other parts of her body with a wooden stick. And immediately she was shifted to so-and-so hospital, and during medical treatment, she died. So here, one she referred on weapon, it's a wooden stick, and the place where I bet is it's a head. So this is her allegation. Now she deposed as PW1, and from the FIR it is not appearing that she is the eyewitness. And now if you read the read her deposition at page number 9 of the paper book, so she simply again repeated the content of the FIR itself. So I know the accused person present in the court today. He is my son-in-law. On the day of Ellie's occurrence, a year back in the night hours at 10 p.m., the accused, who is my son-in-law, had administered several blows on my daughter, baby Kurmi, by means of wooden posts. My daughter had sustained serious injuries on her head and on different parts of the body. She was taken to the Maibong Civil Hospital the following morning. In the early morning hours, my daughter died. So this is again repetition of the content of the FIR. Now, if we come down to the cross part, it is apparent in the first, second, third line of the cross-examination part, it is appearing that I was not present at the time of Ellie's occurrence. I do not know why the Ellie's incident had taken place. So it's appearing that she is not the eyewitness, and why the appellant killed, to that effect, nothing has brought by the mother of the deceased itself. So why I killed, that part is missing, and she is not eyewitness. Now coming to the PW2. So he's a village headman. So his witness is a bit important because he says he was passing by and some commotion was heard. He went and he requested the appellant not to assault the victim. So exactly what he says is PW2. I know the accused person present in the court today. I am the village headman of so-and-so. The incident had taken place on the day of Kali Puja. I was busy at the puja. I had gone to the house of the accused and asked him not to assault his wife. So it appears from this sentence that he saw appellant beating his wife and he stopped. The accused took no heed of my advice and continued to assault. This is enough. So that means this witness has seen appellant was beating and he requested not to do it, but he was continuing. So to that extent, it is appearing that he saw something. But if we read the cross-examination part, to that effect, whether he saw the incident or not, now cross-examination from the bottom, first, second, third, fourth, sixth line from the bottom of the cross-examination part, that is page 11 from top, first, second, third line. The police had asked me to put my signature on a document. I was not aware about the content of the seizure list. So this is not. I had been interrogated by the IO and my statement had been recorded. Now this part is important. It's the fact that I had not stated before the police about seeing the accused engaged in quarrel with his wife, and I had asked the accused to stop quarreling with his wife. I am not aware of any other incident leading to the death of the wife of the accused. So, Lordship, combined reading, it appears in the chief, he is saying that he saw when appellant was beating his wife and he interfered with and warned the appellant not to assault her. Now it is in the chief. Now, if we come to this cross portion, what I read just now, from this sentence, it appearing that portion of that he saw beating his wife was not spoken to the IO, and it is in admitted position. So if that means that part has come before the trial court for the first time.
Amicus Curie,
Lordship.
you are leaving out a number of vital points. Come to the cross-examination, page 10.
Page 10. Lordship.
Read from the beginning.
Right, Lordship. I was on my way to the place where puja was being performed. On the way, I had heard commotion at the house of the accused. On the way, I had warned the accused not to create any disturbance at his house, as his house falls by the side of the road I had taken. The accused did not take any heed of my advice. However, the relevant point of time, I had not seen the accused resorting to any violence.
So he's not an eyewitness.
Lordship,
He's not an eyewitness, isn't it? In his proper.
he,
What he said was he saw some quarreling going on.
uh-huh.
He did not see anything that the.
Lordship, this sentence, I
accused
had
was
not seen the
resorting to
accused resorting to any violence. Violence he has not seen.
So
Lordship, that is what. And that part is embellishment that he said in the chief that he saw the quarreling and he interfered. That part is not so believable because this sentence, as your Lordship pointed out, this indicates that he has not seen any violence. And later part, he clarified in the cross-examination that the above part has not been stated to the IO in his previous statement. That means that is a embellishment and that cannot be treated as a good evidence. So I am pointing out that part. So how this part has to be dealt. In my humble submission, this part cannot be believed. First. So that much is the PW2 and that is to be looked into whether he can be treated as an eyewitness to that portion. So that is what the PW2 said. Now, Lordship, if we come to the PW3, again, he is the neighbor. PW3 is neighbor, Sanjay Gwala. So he is also not saying something. I know the accused person present in the court today. At the 11th point of time, I was at the Puja Mandap. I had heard later that the accused had killed his wife. The wife of the accused had died of injuries sustained by her at the hospital. In cross, the deceased is not my blood sister. I do not know anything about. So, no importance of this witness. Now, similarly, PW4 is also a neighbor. Now, what he said, Kavita Kurmi, what he said, I know the accused person present in the court today. The accused is my immediate neighbor. I had heard that the accused had assaulted his wife and had fled away. So she heard only. The incident had taken place in the night. I had heard that the wife of the accused had died of the injuries of the following offenses. And cross-examination, on the day of Ellie's occurrence, I was lying sick on the bed. I had not made any movement due to my illness. So she is also not an eyewitness or she has no direct part of knowledge regarding the incident. So this PW4 is also not so relevant. Now, let's say very important part is the PW5. So PW5 is the sister of the deceased. So this is very important witness and what she said, I know the accused person present in the court today. The accused is my brother-in-law. On the day of Ellie's occurrence, after having taken meals, I along with my children went to bed. Then suddenly in the night, I had heard commotion at the house of the accused and learned that the accused was beating his wife. I had gone to the house of the accused. When I had tried to intervene, the accused had also assaulted me. She is also made injured. My sister had sustained injuries all over the body. She had been taken to so-and-so hospital in ambulance and the following morning in the early hours, my sister died. So she said she saw and she too was injured by the appellant. So her evidence is very important. Now coming to the cross part, I had gone to the house of the accused on hearing the accused beating his wife. The accused has assaulted his wife by dragging her to the veranda of the house. It is not a fact that at the time of Ellie's occurrence, I was sleeping at my house with my children. I had not seen the incident. So, Lordship, her deposition remained intact till this moment. Now, one more thing, this witness has not pointed out that wooden stick. One hand, she is saying that she interfered, even she was injured, as if she has seen everything. But she has not referred that wooden stick, that is, in what manner the appellant, the deceased was beaten by the appellant. First point. Now she is saying that during the period of assault, she was there. Now, to that effect, if I read PW7, PW7, I'll read it right now. So PW7 is saying that he was also present, but this witness is not referring to PW7. For that reason, I will have to read that PW7 right immediately after this.
PW6.
PW7 I will read. PW6 I will come later because PW6 will of not so much important. PW6 is a neighbor and has not seen anything, so we can skip it. I had in cross. I had not seen the Ellis occurrence, so PW6 is also not an eyewitness, no relevant. Now immediately after PW5, I would like to come to PW7 because as like as PW5, PW7 also come at the same time. Now PW7, he is also the brother of the deceased. 5 was sister and his brother. I know the accused person present in the court today. The accused is my brother-in-law. The deceased was my sister. On the day of Ali's occurrence, having heard commotion at the house of the accused, I had gone to his house and had found the accused assaulting his wife and had seen profuse bleeding on her head, on the head of my sister. I had asked my elder brother to take their sister to the hospital immediately. The following morning, I learned that my sister died of injuries sustained by her. The police had come to the PO and had seized one wooden stick at the PO. I had put my thumb impression on the seizure. In cross-examination, this witness says, I had put my thumb impression on the seizure list at the police station. I am unable to throw light why I had been asked to put my thumb impression. I cannot recollect the date, month, and year of the Ellis occurrence. The police did not interrogate me. So this witness was not even interrogated by police. It is not a fact that I was sleeping at my house at the relevant point of time. My sister was pregnant at the time of her date, and my brother had taken my sister to the hospital. I had seen the Ellis occurrence. Now he is saying that he was present. So, but now this witness has also not stated that he saw appellant beating his wife with the wooden stick. He simply stating that some wooden stick has been seized at the PO, but he is not saying that he has seen that wooden stick. So if we read this PW7 and PW5, then PW5 could have referred that I and this PW7 were present at the time of assault. So despite for this reason, can PW5 and PW7 be believed the deposition regarding their presence? So this creates a bit doubt whether these two witnesses have seen the incident really, because had it been so, the both either way, 5 could refer 7, 7 could refer 5. That part is missing in my while I scrutinize this evidence. So that part. And apart from this, now if we for the time being, if we assume that the blow in the deceased head was with a wooden stick. Now let us read the doctor's medical evidence who was examined as PW number PW8. Now, Lordship, if we at page number 17, Lordship, it's the doctor's evidence card. Now, doctor, while giving the description of the injury, 7 cm into 2 cm into 2 cm lacerated injury, Lordship, injury noted on the left frontal parietal region of the skull, and Les Perts 2 number and 3 number are abrasion. Number 4 is also abrasion. Number 5 is laceration in the noted in the on the chin. Now 6 is the blood clot, and 7 is so and so is the clot. And if we go below that 7, in my opinion, cause of death was due to left frontoparietal subdural hemorrhage, as inferred from signs which are antemortem in nature. As per the nature of injuries, same had been caused by heavy sharp weapon. So if we see that wooden, if we believe that, it is also not corroborating. Had it been with the sharp weapon, so this laceration injury is usually it's contradictory a bit. Laceration indicates some cut, some deep cut, like first layer of skin is cut like this. But wooden, from a wooden stick, can laceration be done? So, and sees this witness is saying with sharp weapon. heavy sharp weapon. And the rest part of the evidence that two witnesses has referred one wooden stick. They have also recovered one wooden stick, but that too without any blood, no reference of blood in the wooden stick. But the one witness has stated that profuse bleeding was seen by him, PW7. So blood was not found. Nobody has told that blood was seen in the ear. And PW5 is also referring to a wooden stick, but not seen, not referred in evidence that she saw assaulting his wife by wooden stick. That part is also a bit gray, not come in the evidence properly. Now, medical report is also not supporting whether it's a sharp weapon or a wooden stick, that part. Now, apart from this, one but one important aspect, Lordship, is the 313. What I did in 313, when questions were put to me, if we see the question number 11 at page number 22, that is very important in the question number. Do you have anything to say in your
Page
defense? It's
number?
page number 22 of the, is the 313 statement recorded. Now, do you have anything to say? What he took the defense is, I had not assaulted my wife with a stick. He denied. Sis had accidentally hit her head against the wall and sustained injuries. We had been involved in a scuffle only. I am innocent. I had not caused the death. Now, this accused in 313 has not denied that he was not in the house. So it is his burden to explain under 106 how the death is caused. To that effect, my submission is, can this explanation is sufficient or not? That but he has also admitted the scuffle. She had he said she had accidentally hit her head against the wall, sustained injuries. We had been involved in the scuffle. So scuffle part is also admitted by this appellant, and he is not denying his presence. So it appears from the case trial that he is taking the bold defense. He is not trying that he was not available that place. So if he is there, it is his burden to prove how the deceased died. And his explanation is one-line explanation. Scuffle was there, and the wife hit her head in the wall and got injured and died. So this 313 explanation, if sufficient or not, that has to be looked into by this honorable court. Now, if we see in the cross-examination of the doctor, in the last line, what PW8, page number 17, Lordship, if we go by the cross-examination, last part, no X-ray or sonography had been done in respect of the injury sustained. Lacerated injuries and abrasion may result from a fall on the hard substance. So this is the admission of the doctor that from hard substance, if somebody had this type of injuries, what the doctor explained can be done. So it is the doctor's statement that blunt force, by falling in a hard substance, that injuries can be, though it is lacerated, that can be sustained. Now, if the explanation given by the appellant in 313 that she herself hit her head to the hard substance, that is the wall, caused this type of injuries, can his explanation in 313 be relied in conjoint reading of this admission by the doctor as regards the injury? So only this aspect, to that effect, only what I scrutinize. But now, if this explanation corroborated by this medical document that is possible, and the presence of PW5, as she was not seen by PW7, whether that evidence will remain or not, whether PW5 evidence is doubtful or not, her presence. Had she been there, she could have seen that wooden piece, what was used. So if this evidence, this explanation and this medical report is considered, then it will be a case of acquittal. Under 106, if it is considered that he explained. Otherwise, Lordship, if PW 5 remains, it will be a case of that can be eyewitness. But I find that PW 5 evidence is a bit doubtful. Had it been corroborated by PW 7,
Any authorities?
Lordship, no other. Only 5 and 7, they are saying that they are present.
If 5 did not see 7,
Lordship,
if PW 5 did not see 7. Or
Yes,
5
Lordship.
was not there,
Lordship,
7 would not have seen 5 also,
Lordship.
correct?
5 should see 7, 7 could see 5, if both of them. And but nobody has uttering that I was assaulting by the wooden piece. Why? If their specific plea is the wooden piece, the blow was there. And in the evidence also no blood stain was found. 7 is saying that some profuse bleeding was seen in the head. That is also one aspect. Now PW 5 presence, if it is doubtful, then if 313 explanation and this medical report that injuries can be sustained in a hard substance, if read together, so it will be a case of that he discharged his burden under 106 by giving an explanation. Because this is not a case that he is not present there. And he is also admitting the commotion.
That's why I'm asking, do you have any authorities in your support?
No, no other. Not no other. I have not given defense evidence. I have not reduced defense evidence also. Huh?
Citation. Citation.
Huh?
Citation.
Oh, citation. Also, citation I have not got because these factual aspects only.
Bring some citations,
Lordship,
you bring some citations, bring some authorities.
Citation.
I did alone. Then okay, Lordship, I will bring certain.
Let him bring some citation. You're Mr.
B. Bhagavati.
Heard Mr. B. Bhagavati, Leonard Amicus Curie, also heard Ms. B. Buyan. Additional to hear some. List the matter for hearing. After 1 week,
Lordship,
after a week. That is sufficient, I think, for today.
19.
file.
I'm appearing on behalf of the amicus curie method. The report was
Yes, my lord, report was called for by this honorable court regarding the status of the informant. He expired, your lordship informant. I got a report.
What?
For service on the informant, your lordship. The earlier occasion.
PW2.
Okay,
PW,
respondent to has passed away.
yes.
Yeah.
Yes.
I not be taken up for hearing. Any method. The amicus is. Yeah, to leave for some personal.
Amicus is not, you are not the.
I'm not that. I'm appearing on behalf of the amicus curie. My lord, get to leave today because of some.
Okay, on request made on behalf of A. Goswami, Leonard Amicus Curie. List the matter after 2 weeks,
Any time.
2 weeks.
But in the next two items also he's only the amicus.
Same order,
28, 20 and 21.
same order. Same order.
Obliged.
If we